Good day, everyone. Welcome to The Real Truth. I'm Tommy Spina. Today's guest is Barry Ragsdale, a very, very, very smart lawyer with Dominic Feld and Hyde, a well-known law firm here in town. And I've known Barry for decades. I don't know exactly how many. I've lost count. I know we're both getting old. Hello, Barry. Welcome to the show.
Hello, Tommy. I appreciate that introduction. Thank you.
How long have we known each other? 40 years?
I'd say 40. I've been practicing 41.
Yeah,
And
I'm at 48.
okay. I think I met you early on. So we'll just say 4 decades. It makes it sound like a
I'm going for the gold pin at
excellent.
50 years.
Good luck with that.
So, it, probably a lot of you do not know, but on Wednesday of this past week, which is exactly a week ago from the date of this podcast, Barry filed on behalf of 3 or 4 individuals. Is sort of immaterial, I think, to this conversation, a lawsuit against Thomas Tuberville, also known as Coach Tuberville, or just plain Coach, who wants to be the governor of the state of Alabama. The lawsuit is phrased with a Latin word that I haven't heard since law school called quo warranto. I think I pronounced that right. Did I?
I think you did. Yeah.
So for the listeners who haven't seen the complaint, can you explain, one, what quo warranto is and what is the central claim that you're asking the court to decide about Tuberville's eligibility to run for governor?
Sure. Quo warranto is one of those Latin phrases that lawyers use, so not everybody can be a lawyer. But
sort of like res ipsa.
There you go. It relates to by what authority. And
That's the literal translation.
Yes, I did not go to a school that taught Latin and have had very little reason to use it, but Google is your friend. But it literally translates into by what authority. And it is a ancient cause of action that existed at the common law in most states, including Alabama, have a statute sets out the quo warranto cause of action. And essentially what it is a legal claim by which, in this case, citizens, any citizen in the state of Alabama can bring this to challenge whether or not a government official or in this case, major party nominee has the authority to hold the position that they are seeking. And the Alabama Supreme Court over the last 20 or 30 years has made it very clear that quo warranto is the proper legal challenge that needs to be brought when you're challenging a candidate or an officer's eligibility for office. There are restrictions on election contest. I may be telling you more than you know, but
no, keep talking.
Election contests are very strictly.
I'm going to use another Latin phrase, tabula rasa,
Okay.
which means clean slate. Pretend like you're talking to a clean slate because we know nothing.
Okay, I will do my best. And I've handled a lot of these cases going back. I tried to look. I think the first time I got into kind of this general category of election law and qualifications for office, believe it or not, goes back to the time that there were a bunch of people challenging President Obama, you may recall, claiming that he wasn't a natural born citizen, wasn't born in the United States. And a bunch of those folks actually got to filing lawsuits. And I represented the Obama campaign and the Alabama Democratic Party in defending those lawsuits. They were obviously pretty easy to defend, frankly. But that really got me into the law regarding this. And since even before that time, the Alabama Supreme Court has said, look, if you're challenging the qualifications of either a candidate or an elected official, quo warranto is the proper way to go, not an election contest. Although election contests have their place, both parties are empowered by statute and by Alabama law to resolve inter-party or intra-party, I guess, election contests on their own, because parties get to pick their nominees. But once the nominee is certified, the law says quo warranto is the proper way to go. So that's why this lawsuit is based on that cause of action and the statutes that govern quo warranto in Alabama.
Well, wouldn't a contest be something that would be filed after an election? Or, I mean, just
yeah.
logically speaking.
Yes. The statutes in Alabama provide for a contest to be filed with the party, the state party that you're dealing with, either the Republicans or the Democrats. First, before a primary, there's a pre-primary challenge. Then there's a statute that allows a post-primary challenge to be filed. That's what Tuberville's opponent, Mr. McFeeters, recently went through with the Alabama Republican Party, a post-primary challenge. And then there's a third type of election contest that can be brought after the general election. But in between that, quo warranto is the remedy. And what the court has said, and I think it makes sense, is both voters and, frankly, the parties need to know before you go through the whole process of a general election whether or not their candidate is actually eligible for the position. And that's what we're doing, is challenging right now whether or not he can properly be certified and put on the general election ballot, given the fact that he doesn't meet the constitutional eligibility requirements.
You mentioned two things that actually triggered a question in my mind, which is mostly my job in this dynamic is to be a better listener and try to pick up on something that makes me want to ask a follow-up question. So you're operating under Section 117 of the Alabama Constitution.
Correct.
And
that's right.
That is for Alabama, who has an exceptionally long constitution, but it was recently ratified, I guess is the right word, by the citizens, and Section 117 survived. But why do you believe that it clearly, in plain language, excludes or disqualifies Tuberville based on his residency timeline? Now, I know in the complaint you spell out many facts that listeners will find very interesting. We cannot make that complaint available to you. So for those that are listening, I think if you Google it, you'll probably find it, but it has not gotten much press. So walk us through Section 117.
Okay. One of the things we point out and that our research uncovered is this provision in one form or another has been in every constitution that Alabama has ever had, dating back to 1819. There are a lot of bad things about the Alabama Constitution. Frankly, we cured a bunch of them, took out a lot of the racist language and a lot of the unwieldy restrictions on local control and some of the other things when it did get ratified by more than 3/4 of the voters in 2022. But this provision containing a durational residency requirement in the Alabama Constitution has been in every constitution that we've ever had, with one exception. The Constitution that was enacted in 1868, which coincidentally is called the Carpetbagger Constitution, omitted that provision. And the reason was it was written by a bunch of people who didn't live in Alabama and who wanted to be able to run for office. So
here we are.
There we are. But the 3 or 4 versions that we've had of the Constitution that's been enacted since 1868 has also had this provision. And it puts 3 basic requirements on anybody who wants to be either governor or lieutenant governor. It's the same requirement. One is they have to be 30 years old. The other is that they have to be a citizen of the United States for 10 years. I think some people would be surprised that it's as short as it is, but you have to have been a United States citizen for 10 years. And then the most important part is you have to have been a resident citizen of Alabama at least for 7 years right before the election. So it's 7 consecutive years, and it's the 7 years before the general election, which is in November of this year. And so those are the 3 constitutional bedrock requirements to be either governor or lieutenant governor. And I will say the other thing that we point out in the complaint is that's not an unusual provision. 20 or 30 other states have very similar provisions in them. And those provisions, and particularly Alabama's, is intended to make sure that whoever's going to be elected governor, it's not just that they live here, but they've been amongst Alabamians for a reasonable period of time, and this time 7 years, so that they understand the issues, the problems, and the advantages of being an Alabama citizen. And so the courts have upheld these kind of residency requirements for candidates for office, in particular for circuit judges and others. We've never had, frankly, a out-of-state resident try to run for governor of Alabama that I can find. So this is the first time that law is going to be applied to governor. I think because everybody before Mr. Tuberville understood what the Constitution said. Right. And so, but we're very comfortable with the fact that the constitutional requirement means what it says, and that it applies across the board to people running for office for governor and lieutenant governor.
Well, factually, of course, you've laid out specific reasons why he should not be allowed on the ballot. I suspect there's a response that will be coming, hopefully, relatively soon. I notice you've asked for expedited, which is not generally a word that our legal system lends itself to overall. And we are working in a very short window of time. So do you realistically expect that we can get this case tried and appealed by November? And I noticed you demand a jury trial. I didn't know that would be a jury trial issue, but I find that interesting as well.
Well, let me take that in order. Yes, I think it can be done and resolved before November. And, part of that is based on the fact that the statute that establishes this quo warranto cause of action and the case law from the Alabama Supreme Court says these kinds of cases have to take priority. It's not just that I want it to be expedited. The law actually requires that it be expedited, and with good cause. The courts have said, look, this is, the qualifications and eligibility of a candidate for office needs to be determined quickly and promptly and in such time so that voters can, be apprised of that resolution, but also to the extent that a state party retains the ability to replace a candidate on the ballot, the party needs to know that. And so, one of the things that we've asked for is that the time for responding to discovery be shortened. The statute itself shortens the time. Normally, as you know, you get at least 30 days to respond to a complaint. The quo warranto statute says you get 5 days after you're served. So we expect this to move at a fast rate. We've got a great judge that we drew in Montgomery County who is a no-nonsense type of judge, and we think we'll apply the law and expedite it. This is going to ultimately depend on how much delay Tuberville's lawyers are allowed to get away with, and whether or not the Alabama Supreme Court acts in such a way that it is also expedited. If they follow their own law and follow their own cases, they're instructed to rule quickly and to expedite the case. So I'm confident that we can get it resolved. I'm also confident that Tuberville and his team of white stocking lawyers, is that still the term?
I call them tassel loafer lawyers.
Tassel loafer lawyers. Whether or not
white stocking is it. I
What was that,
noticed.
Mr.
I
Petty?
noticed you served or CC'd Wallace Ratliff and Jordan in Steve Shaw's group. Is that the defendant's lawyers?
Well, they represented Tuberville in front of the Republican Party challenge that Mr. McFeeters brought. So they have been his lawyer. I think they will continue to be his lawyers. I did that primarily out of courtesy. If somebody sues my client and they know that I represent that client, I consider it a professional courtesy if they let me know about it.
Absolutely.
So I know both those fine lawyers at Wallace Jordan, and I sent them a copy. I also asked them a pretty routine question, which is, will you accept service of process on your client? Which I routinely do, and I bet you do for
I do.
clients.
For
Just to
grand jury subpoenas and things that I do in the criminal realm, I will
exactly.
accept service. It's a courteous thing lawyers do for each other. Did they
Yes. It
agree to
also,
accept service?
yeah, no, I've heard nothing back from them. I'm taking into account that it was. I only sent it to them on Wednesday. Friday was a holiday. I'm not sure they celebrate, but I did. And so I'm gonna give them to the first of next week to give me a response, and then we'll just go through the process. I mean, we can send a process server to track down Mr. Tuberville. Maybe in Florida, but we'll get him served and get this process going. I don't know any reason why they wouldn't accept service unless they're just trying to gum up the works and slow the process down. I expect them to get back with me and tell me that they'll accept service.
Well, he shouldn't be too hard to find. He's in
No, he's
probably
pretty.
one of one place.
Yeah.
um, the timeline is just fascinating, and how well you investigated the details of when things were done leading up to his qualification to put his name on the ballot. You raised something that triggered a thought for me. The McFeeters matter was mostly administrative and not judicial.
Right.
So does that have a sort of like other administrative actions we have in the business we're in, recourse in the court system, because you wouldn't want to get in each other's way. To me, your way seems to be the most expeditious way to get from A to B.
I think so. I mean, the courts prior to a candidate being certified as a nominee give a lot of discretion and authority to political parties. And I've been involved in those kind of contests in the party system on behalf of Democratic candidates on numerous occasions. And as I said, up to a point, the courts defer to state parties to make a decision. But once that nominee is certified, the party no longer has any authority in terms of picking their nominee. They've made the decision, and that now they got to live with it, frankly. And I put a lot of the blame, maybe most of the blame, on the Republican Party for not, frankly, deciding that the Constitution applied to them and their candidate. They could have easily looked at this and said, you know what, this doesn't pass that. We got plenty of other, maybe not plenty, but we have several other good potential candidates that don't have a question about their residency, that don't have a question about their constitutional eligibility, but they chose to ride this horse, and that's on them. It's on Tuberville for expecting people to be as dumb as he is and believe that he lives at this little tiny house behind the Kroger in Auburn.
One bath.
Yeah, one bath. As I said, I think it's time for the party and for Mr. Tuberville to reap what they have created. And as I said, I think it's important to point out this is not a technicality; it's the constitutional requirement.
Well, wouldn't they have access to the same databases and facts that you've represented in your complaint? Or do they just choose to ignore that and believe that they're above? My first season was about the rule of law because I felt like it was disappearing. Well, here's a classic example of the rule of law and is and are the decision makers or the fact finders, for lack of a better word, which would be the fact finders would be the jury.
Right.
And then if it goes up on appeal, I assume they would skip the Alabama Court of Civil Appeals and go straight to the Supreme Court.
Right. That the Supreme Court has jurisdiction here, so they would. The appeal is to the Alabama Supreme Court. We expect, frankly, to make at least one or more trips to Montgomery. I think Tuberville and his team are counting on a couple of things, and I think they are, perhaps without justification, but we shall see. But I think they're counting on the all-Republican Alabama Supreme Court maybe to bail them out here. And
similar to the United States Supreme Court.
Well, very much
part of the United States Supreme Court.
Yes. Well, and it's I will say this, and it was kind of has been disheartening to me, the number of particularly lawyers that have come up to me and said, you make a great case, you'll have a good judge in Montgomery County, but the Republican Supreme Court's never going to let you win this case. And it's disheartening to me that so many people in our profession and frankly just in the general citizenry have such a low opinion of our judges and our appellate judges in particular, that they just assume that the court will just do the political thing and support Mr. Tuberville. I frankly have more faith. I know all of the members of the Supreme Court. I've appeared before them numerous times. I particularly have a lot of respect for our Chief Justice. And I think that when it really comes down to it, they'll do the right thing. Now, I will tell you, I think the right thing probably would be for them to recuse themselves because of their own political connections to our senior U.S. Senator. But there's also a reason for that. If you want to really remove politics from it, you should appoint a special court of retired judges and justices. And that's not something I made up. I've had numerous cases, and there's been many more, in which the court has done exactly that. Probably the most recent that I can recall was when Roy Moore and his various misconduct was before the court. The court recused themselves because they had either run for office with Mr. Moore or been on the court with him, and they appointed a special court of retired justices and judges who don't have to be political anymore. They don't have to run for office. And so that's a fairly common practice. I think there's a very good chance that that'll occur in this case, and that we will have the case decided by respected judges and justices, again, who don't have to stand for re-election. And I think that largely takes politics out of it.
Well, is that the role of the governor to appoint those judges, or who is the appointor?
The appointor in this case is technically the Administrative Office of Courts with the guidance, guidance of the Chief Justice. And I will say I've had cases where I actually fought over who got to appoint the special court or special justices when that was done. I believe in this instance, it will be the Administrative Office of Courts under the guidance and recommendations of our Chief Justice, which is what it should be.
You said you had the cases filed up, I don't know if I said this, I think I did, in Montgomery County.
Correct.
And that's probably because I noticed Wes Allen, the Secretary of State, who is the chief election officer, I guess, is included as a named defendant. Is that what makes that venue appropriate?
It does. In addition to that, the quo warranto, I hate to keep coming back to that, but the quo warranto statute, okay, it specifically says venue is appropriate in Montgomery County, which is, as you may know, administrative proceedings and things involving the government are supposed to be filed in the
county. Yeah, even the lowly driver's license issues are filed in Montgomery County.
Yes.
What judge has the case in Montgomery County?
It is assigned to Judge Brooke Reed, who I will tell you, I don't believe I've had a case in front of, but was appointed by Governor Ivey, recently ran, and I think was reelected maybe 2 years ago. She has a tremendous reputation. Obviously, when lawyers get a case filed and get assigned to a judge, you call other lawyers and talk to them about that judge. And universally, Judge Reed is very highly thought of, considered to be very impartial, both politically and legally. She's not considered a plaintiff's judge or defendant's judge. She's somebody who has a reputation for strictly following the law and not tolerating any nonsense. That may not work to my benefit as far as the nonsense, but I think she's a very good draw. And, I think, frankly, the Tuberville contingent can't really complain about her. She's not somebody who has ties to the Democratic Party or any of those kind of things. So I was very happy when we drew her, and we shall see. But I fully expect her to apply the law and to do the right thing in this case.
Who, under Alabama law in this dynamic, carries the burden? You?
It's interesting. I think I have some initial burden of showing that at least at some point in time, Mr. Tuberville was not a resident citizen of Alabama. I think that's easily satisfied here. In the instance that he registered and did vote in Florida. And so we know that in 2018, he repeatedly claimed that he lived and was a permanent resident of Florida. So what the law then applies, and there's literally a century of law that holds this, is that if you can establish that somebody was a resident of another jurisdiction, another state, another county, the burden shifts to them to prove that they have permanently relocated their residency.
So you don't have to prove that he wasn't an Alabama resident by 2019.
Correct.
He would have to prove that he was.
Correct. And, we think it frankly, even if we had the burden of proof, we set out a tremendous amount of evidence in the complaint, which is a little unusual, but we thought this was an unusual case where we needed to make sure that both the court and frankly, the general public understood that this isn't just some, throw it up on the wall kind of case, that there is tremendous evidence, overwhelming evidence, in my opinion, that he lives in Florida, has lived in Florida. Now, he started trying to create a paper trail. I refer to it as manufacturing his residency when he decided to start running for office. And he did some things that are typical of what you would do if you were trying to create a false paper trail of being an Alabama resident. He got a driver's license, he registered to vote. But frankly, he was pretty sloppy. And more importantly, it just doesn't pass the smell test. You drive by and look at that little tiny house behind the Kroger in Auburn, surrounded by other college students.
I used to live there. And yes, I did read paragraph 21 of your complaint.
Okay.
And as an Auburn graduate, I don't take offense that Tuberville lost his last 5 games at Auburn. Quite frankly,
got it at his tenure at Cincinnati. That's when he retired from football. But he damn sure lost his last game at Auburn. I remember it well, 36-0, Roll Tide. But we'll say this is not, and it's funny because people already on the internet and elsewhere have attacked me as an Alabama fan, which I proudly accept. That isn't why I brought this lawsuit.
Well,
and
you're
it's
not alone.
Well, exactly. And I have co-counsel in this case, a great lawyer named Jimmy Poole.
I know Jimmy.
Former judge. Well, there is no more obnoxious Auburn fan in the world than Jimmy Poole.
Well, our governor's an Auburn fan.
Well, there you go. This transcends, some lawsuits transcend politics. I think this does, but more importantly, it transcends Alabama versus Auburn. I think Auburn fans agree that the Constitution is the supreme law of the land and needs to be followed. And so, but as I said, we covered the bases. We have an Alabama fan and an Auburn fan. My co-counsel with me in my law firm is Robert Vance, and he didn't go to either school, so he's neutral on.
No, and he's smart, and he's married to Joyce.
He is definitely, well, that's actually Joyce's son. This is
Oh, it's little
it,
Junior Vance.
Junior. It's actually Robert the Third.
Yeah, I met
Yeah,
him.
to him as a
I,
young lawyer. He's not that young, but he is brilliant. He is no
compared
no
to us, he is young.
yeah, absolutely. And anybody that me will not have trouble accepting the fact that he's the brains of the operation. Brilliant lawyer, former federal law clerk, and so we're very lucky to have him with the firm, and very lucky to have him in this case.
Yes, I try to surround myself with those people too, because that's not my skill set
Yes.
particularly either. So you've laid out in your complaint facts, almost like it's reminiscent of what happens when the Alabama Department of Public Examiners release an audit and accusing someone of misappropriating some money, and that person rushes to pay back the money.
Right. Yeah.
In this instance, it looks like Tuberville rushed to try to cover up his tracks, but in the process really exposed himself to proving your case to a large degree in his actions. So if you had to address one piece of evidence that you feel exceptionally strong about, which one would it be? Is the most damaging to his claim that he's an Alabama resident?
Well, lawyers hate to give just one example, and I will say that part of why we set the complaint out the way we did is because it's one piece of evidence after another. But I think the fact that he has publicly claimed on his tax return that he moved to that little Auburn house in August of 2018, but we know he voted in Florida in November of 2018, which would be a felony. You swear when you both register to vote and vote that you are a permanent resident of Florida when you do that. And so, that doesn't add up. The truth is he's very experienced at it, but he's not very good at lying. He has had to backtrack 3 or 4 times about when he actually moved to that Auburn house. I think his lawyers are now saying, well, he started moving in August of 2018. Well, even first of all, that little house in Auburn is so tiny, it wouldn't take you long to move your couch and your dresser in there. But so I think the truth is the most telling thing and the most damaging thing about this case is that when Mr. Tuberville gets under oath and I have an opportunity to take his deposition, I think this whole house of cards is going to collapse. And so as I said, I would certainly point to the fact that he voted in Florida, swore he was a Florida permanent resident after he claims that he moved to Auburn, is a pretty good sign that he is not really an Alabama resident. Now, we also frankly expect that we're going to discover that he reported income on his federal income tax returns, which nobody has seen at this point, or at least nobody in the public or on our team.
Somebody slipped up on a barcode.
Well, they did. That to me is kind of I get a chuckle out of it. It also pains me as a lawyer because I suspect it was the lawyers that messed that up. They made a big show, obviously, in front of the Alabama Republican Party of saying, look at our tax returns. Look at them. Here they are. They prove that he was an Alabama resident. And when people start looking at it, they see this barcode, which is easily readable with free software that's available on the internet, and it discloses everything they tried to redact. And it raises some very significant questions. I think the fact that they threatened to sue a journalist who had just applied that free software to the barcode, threatened to sue him into oblivion, was a pretty good sign that they had messed up and that they had revealed information that was damaging to Tuberville's case. On that 2018 return, for example, that he released, he only reports $30,000 in income. Now, this is a guy that that got paid millions and millions of dollars by 2 or 3 different schools not to coach. And if anybody believes he only made $30,000 in that year, there's a bridge I want to sell him in Elba, Alabama.
Well,
but
maybe he's talking about money that he made in Alabama only.
Well, that's what we think. We think that is what he did, that he reported his only Alabama income. And of course, if you're, and you know this obviously, and most everybody else does too, if you're an Alabama resident, you have to report the income regardless of where you earned it.
Yeah, gross receipts.
Exactly. And so we think that raises a huge question. And in fact, he indicated on that same tax return that he reported income on his federal return that he didn't report on his state return. So one of the things we've asked the court to do is to provide us, make Tuberville produce his federal returns. He's using his state returns like they exonerate him, and they do not. But it really only raises the question, okay, well, let's see what you did when you reported to the feds. And we fully expect them to fight us on all of that. One of the things we've said is, well, you can give it to us under a protective order, which is a court order that says the information can't be shared outside the lawsuit, that we'll keep it confidential, so that he doesn't have to worry about, it may be other crimes that he committed getting exposed by his federal returns. But we think we're entitled to see that, particularly since he's now trying to use his state returns to prove his residency. That requires some comparison with other information, including his federal returns. So, we fully believe that if we had to stop right now, we have enough evidence to show that there's just no way he's an Alabama resident or has been an Alabama resident since before November of 2019. But we also expect that, given the opportunity to depose him and frankly depose his wife, who theoretically also lives in that tiny little house behind the Kroger in Auburn, and get the information that we've requested, that it'll be a slam dunk to be able to show that he's just lying about where he lives.
Well, doing what I do for a living, it seems to me that there's the potential, if someone were inclined to take it upon themselves, that had prosecutorial discretion, either in the state of Alabama, but more likely in the state of Florida, the significance of his 2017 Florida voter registration and how it comports with Florida's Constitution requirement that voters be permanent residents of the state and the county where they vote. If he swore to that, then he's lied on something. One form, I mean, it's are you lying now? Or were you lying then?
Yeah.
It's that kind of a dynamic to me.
Well, the only thing I would bicker with you is I think he's lying then and now. But I understand what you mean. One of those things has to be true. And they've tried 3 or 4 times to come up with an explanation of how he could claim that he lived in Alabama 6 months before he voted in Florida. But I haven't heard one that makes sense. And as I said, I think this arises out of kind of the arrogance that Tuberville has had, particularly in political office. He just assumes that he can say something and everybody's going to believe it. Well, we don't believe it. And we think it's a lie, and we think we can prove it's a lie.
I asked you about who had the burden. I did not ask what the standard of proof is.
It is a preponderance of the evidence.
So for those that don't know, that just means 50% plus
correct.
A little bit.
Right. Is it more likely than not that either we've proved our case or that Mr. Tuberville has failed to prove his case? And let me say that the request for a jury trial, I waffled on that. I didn't know whether we really wanted a jury trial, but the quo warranto statute, by law says that these cases can be decided by a jury. That presents a little bit of a timing problem because, as you know, it takes longer to get a jury trial put together and formulated than it does a non-jury trial. But, ultimately, it's funny because Tuberville in his campaign says, let's let the voters decide. Well, we think let's let the public decide. Let 12 jurors hear the evidence and make the decision. Let the judge enforce that jury verdict. We think that your average person who sits on a jury is just never, ever going to believe the stories that Tuberville makes up about where he lives. And we don't believe in particular that they'll look at that little house in Auburn and say, yeah, that's where the multimillionaire that's made millions off illegal insider trading, that's where he lives. Sure. We don't believe that a jury will believe that for a minute.
Well, there's a lot to talk about here, and we are just touching the surface. I would like an open door with you, if that's okay, as this
Absolutely.
progresses, because I don't like my podcast to be too long, and we're hitting close to the end of what I have allotted for people to have to bear to listen to both me and you. We're at that point where it's time to say goodbye, but I would like the opportunity to allow things to proceed and follow up periodically until we get to some decision made by either a judge or a jury. I guess you could always waive your jury demand, but
Yes.
I hear what you're saying.
Yeah.
If he wants the people to decide, then let's let the people decide what you've
Exactly.
alleged in the facts of your complaint.
Let me, can I say one thing, Tommy? Because you started and you said that the lawsuit had been brought by two citizens that, you know, who they were didn't really much matter. I'm paraphrasing and probably being unfair to you, but in this case, I think it does matter. Both of the plaintiffs, both of my clients are military veterans who served this country, who took an oath to uphold the Constitution. And that's not a coincidence. Senator Tuberville has been the worst senator for veterans, maybe in the history of senators.
That's for sure.
Consistently voting against veterans' interests. Early on, you may not remember this, but I promise the veterans do. He promised to contribute his salary to veterans' causes. That was just another lie. He's never done that. He voted against and held up promotions of military folks, really incapacitating a lot of the military operations. So it is not a coincidence that these two plaintiffs are proud veterans who served this country and who believe in enforcing the Constitution. And I just wanted to say that.
Well, I'm glad you did. I did not mean to make slight of the named parties. It wasn't my intent, but the focus is definitely on the underlying facts, no matter who brought them. But what you just said, it gives it extra added impetus. The reality is you can't be a part-time Alabamian and a full-time governor.
Absolutely.
You also can't help but ask the question, is this a governor's race or a Florida vacation interrupted by campaign stops? I can't quite decide how to pigeonhole it, but I guess ultimately the question will become, is the Alabama Constitution stronger than party politics?
Absolutely. I think that's the perfect way to put it. You know, and I do say this. I say voters need to ask themselves, and citizens in general need to ask themselves, that if a politician will lie and violate the Constitution to get into office, just imagine what he will do once he gets power. And so that's why we need to draw the line at this point, and that's what this lawsuit's all about.
Well, thank you for being with me. This was The Real Truth, and this is The Real Truth. Barry Ragsdale, have a great day. I'm sure I will be following up with you.
Thanks, Tommy. I appreciate what you do.
Okay, have a good day. Thank you for joining me today on The Real Truth. My name is Tommy Spina. I hope you enjoyed today's conversation. I hope you will follow or subscribe to my podcast and listen in to the next episode. If you found it valuable, please take a moment to rate it and review it. It helps us to reach more listeners that care about the issues that matter. Share it with a friend. Stay engaged and remember, the truth matters. I'll see you next time.